With public trust in the Supreme Court wavering, and that's being generous, amid scrutiny over the financial dealings of some of the justices, Democrats on the Senate Judiciary Committee are moving forward with a bill that would overhaul the High Court's transparency requirements. The bill would, among other things, require the court to adopt an ethics code, as well as impose more rigorous rules for disclosure of gifts, travel, and income. The legislation cleared the committee along party lines. Senate Republicans accused Democrats of playing politics.
Liberal Democrats have been trying to destroy the Roberts Court for quite a while now because they don't like the outcome of certain decisions.
Rhode Island Democratic Senator Sheldon Whitehouse joins us now. He serves on the Senate Judiciary Committee and is sponsor of the Supreme Court Ethics, Recusal, and Transparency Act. Senator, good to see you. Briefly, tell us what the legislation would require that's not required now.
Well, it would require the Supreme Court to adhere to the judicial code of conduct that all other judges must follow. And to make sure that they do, it would actually create a procedure so that whether a justice is violating the rules or not actually gets determined by someone. It would also require more disclosure to match what members of Congress and executive officials are required to disclose about gifts of travel and hospitality and other things like that. It would require, when a recusal question is raised, that the justice write why they did or did not recuse, so that there's a record of some kind. And then it would require the much better disclosure of these little flotillas of what are called amici curiae, friends of the court, groups that come in and file briefs with the court. It's kind of last-minute lobbying with the Supreme Court before they render a decision. And a great number of them now are essentially fake organizations screening for big special interests. And we think that the groups that fund them and the real special interests behind them and whoever actually wrote the brief should all be disclosed.
And what would the public, in your opinion, Senator, learn that it can't learn now?
Well, some really simple things like how many gifts did Justices Alito and Thomas get from the 6 right-wing billionaires who have now been documented to have given them various kind of gifts? Second, with respect to Justice Thomas's recusal in the January 6th case, the simple fact that needs to be known to determine whether that was lawful or unlawful is what he knew about his wife's activities related to that case and when did he know it. So you'd get an actual answer to that question that would support a determination as to whether it was legal or illegal for him to have failed to recuse himself.
Senator, as you know, Republicans have said there are some very serious separation of powers issues involved here, that Congress ought not to be intruding on the Supreme Court's business. Your opinion on that?
That's one of the funnier arguments that they make because it has absolutely no merit whatsoever. In fact, if you look at the body that right now oversees the conduct of the justices and the federal judges, it's called the Judicial Conference, and it was established by Congress. And if you look at the requirement that they have for financial disclosure, that was a law that was passed by Congress. And if you look at the rules about recusals, those pertain to a statute passed by Congress regarding recusals. So essentially what they're saying is it is not Congress's business to look at how a body created by Congress is implementing laws that were passed by Congress. And that obviously makes no sense at all.
And address Lindsey Graham's criticism that the only reason Democrats are interested in this is because they don't like recent Supreme Court decisions.
Well, the more interesting point is that in the long, long markup of my reform bill, not one Republican on one occasion defended any of the reported misconduct by the justices. So they're trying to change the subject to how evil is the Democrats' motive, as opposed to, wait a minute, is there really a problem at the Supreme Court? I think the facts will show that there really is a problem at the Supreme Court. And some of our best witnesses, I think, are going to be federal judges who know where the guidelines are, what the rules are, and are getting increasingly irritated with the court for not following the rules and guidelines that they have to follow.
Speaking of good witnesses, would you like to see Justice Alito and Justice Thomas appear before the Judiciary Committee, and how willing are you to go to the subpoena if that's necessary?
I think in due course, it could be very valuable for them to testify and explain what was going on. But in the same way that a good lawyer prepares for a deposition before they go into the room with the witness, we need to be able to do the investigative work to find out exactly what went on, to see the documents. And at the moment, we're getting zero cooperation so far from any of the billionaires that we are pursuing who have been lubricating the court with free travel and hospitality and gifts.
So are subpoenas on the table either for them or the justices?
I think subpoenas are a very natural result, a very appropriate result for Congress, established by law that we can do that if we continue to get a stonewall and no cooperation. Again, you do these things in proper sequence in a good investigation. So I don't want to get ahead of my skis, but clearly there is a path to subpoenas.
I want to ask you, Senator, about something that has gone on in Alabama. The legislature there, controlled by Republicans, is refusing to adhere to the high court's decision that it redraw congressional districts there to include a second majority-minority district. Your thoughts on what's going on there and a state's apparent willingness to defy a Supreme Court order?
Well, I suspect that this goes back to court, and the litigants point out what's happened and that the Alabama legislature just defied the Supreme Court. And then what ordinarily happens then, I believe, is that a special master gets appointed to manage the situation, and a court-approved map is produced. One additional point that I'll add, if the right-wing justices on the Supreme Court had not messed around with Shelby County versus Holder, had not done the damage that they did to the Voting Rights Act, none of this would be happening. The Voting Rights Act, the law changes that took apart these districts and set them up so that there were not enough majority black districts, that would have been held off by the Department of Justice early on. So this is the kind of conduct that you get when you have a Supreme Court that's willing to degrade the Voting Rights Act. And in this case, now they darn well better enforce their decision.
Senator Sheldon Whitehouse, we thank you.
Thank you.